Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Tuesday, February 25th, 2025 at 9:02 in the morning. So we're going to start our week and our day out talking about H-137, which is an act relating to the regulation of insurance products and services. So first we'll have one of our alleged counsel, Jen Carby, join us with an updated amendment, the shared Medigap discussion that we've been having.
Good morning.
Thank you for joining.
Barbie from the Office of Legislative Counsel. So you want me to put new language up on the screen? So I have brought you a new draft of language. I will put up. And the way I typically do things is anything that's new from what you saw last time is both highlighted and bold. Anything that is proposed to be deleted is highlighted but not bold. So we're looking at the Medicare supplement insurance policies language, often referred to as Medigap. And first thing I did was just add the words rate review into the section heading because there are two sections on Medicare supplement insurance in this chapter of Title 8, and it's confusing. So this would say Medicare supplement insurance rate review. And then there's a new subsection A that would say, and a lot of this is based on the testimony I think you heard on Friday from the Office of the Healthcare Advocate. Within 5 business days after receiving any request to increase the premium rate for a Medicare supplement insurance policy from the health insurance company, hospital, or medical service organization, or health maintenance organization issuing the policy, the department, this is Department of Financial Regulation, shall post information about the rate filing on the department's website, including the name of the insurer requesting the rate increase, the overall composite average rate increase requested across all the different plan letters that they offer, the increase requested by plan type, the date on which the proposed increase would take effect, the SIRF, System for Electronic Rate and Form Filing tracking number associated with the filing, and a web address for accessing the filing electronically, whether a public hearing is required, and instructions, which you'll see more about below, and instructions for submitting public comments and the deadline for doing so. Then just added business in a couple of other places. So everything in here would be consistently 5 business days. And as you may remember from last time, within 5 business days after,
You're back. You're back.
After receiving a request for approval of a composite average rate increase in excess of and increasing that threshold to 10%, or any or similar change that the commissioner deems will have a comparable impact on cost or availability on a plan issued by an insurer with 5,000 or more total lives in our Vermont Medicare supplement insurance market, the commissioner of DFR notifies the Department of Disabilities, Aging and Independent Living and the Office of the Healthcare Advocate of the proposed premium increase. And then we have, again, the 5 business days. And then we get into subsection D, and our changes to this come in, as you may recall from last time, we're taking out the whole second independent review by another actuary, but this would add in some additional process. So this would now say on page 4, for any filing by one of these insurers with 5,000 or more total lives in the Vermont Medicare supplement insurance market, in which the requested composite average rate increase exceeds 10%, and we already moved that 5,000 or more lives earlier, the commissioner shall solicit public input and shall, so last time you'd seen this, it was may hold a public hearing. This would now say shall hold a public hearing in accordance with DFR's applicable rules on administrative procedures. So that's if there's, again, if it's 10%, more than 10% increase across all the plans, and they have more than 5,000 or more total lives in the Medigap market in Vermont, there must be a public hearing. And then for any filing that doesn't meet that criteria, a public hearing may be held in the commissioner's discretion. And still it would allow a hearing to be conducted through a designated electronic meeting platform, updating our existing language about interactive television. And then it would specify that in any review held in accordance with this section, the commissioner shall permit intervention by any person whom the commissioner determines will materially advance the interests of the individuals insured under the policy. And then we have the timing piece that we had put in, that we looked at last time, basically 6 months in advance. Repealing that section in Title 33 on the independent analysis. And then a DFR had asked for an effective date of January 1st, 2026 in these sections. So that would just need to be harmonized with your underlying bill.
Questions? Go ahead.
There's the first part, the very beginning, is that currently something that we do and we're putting it in law, or is every step new?
I think a lot of the information is available, but it may not be as clearly stated that it has to be posted, but I would defer to either DFR or the healthcare advocate who have more familiarity with this and from DFR is.
Hi, everybody. Mary Black from the Department of Financial Regulation. So some of that information is posted on our website, but not all of it exactly. But we've talked to our rates and forms people, and they don't feel like there'll be any issue posting that information within 5 days.
We heard from Mike on Friday. I think there was an issue trying to find the information, and this way it would put it right there, easily accessible, more transparency for the public. Any other questions? Jim, thank you. Sorry. Mary, is there any other thing, any of the other pieces you want to comment on? How's the department looking at this new language?
I can get my mic back on. I'll be happy to do that. So I will say that we had struggled for a while to try to make this so that it would not be a contested hearing, because that obviously raises a lot of process and lengthens the process and so forth. But talking to the Office of Healthcare Advocate and our impressions from what you were looking for, the only way to do that would be to make that hearing a may instead of a shall. If we make it a shall, we're going to trigger the contested hearing requirements because of the other statutory language that's on the books, the regulation, and the court interpretations of what a contested hearing is or is not. So Blue Cross obviously has some reservations about that. They've said that they will deal with it, and we've committed to trying to make that process as expeditious as possible. But it will be constrained by a lot of process because it's a contested hearing.
Michael, would you like to?
So Mike Fisher, Healthcare Advocate. I think our wish and what we would work towards is that this does not look anything like the hearings that happen in the QHP world, where there's presentation of evidence and cross-examination of witnesses and all that stuff. We're not at all looking for that kind of thing. And my understanding is that informal disposition and easily made by agreement of the parties. And so I think though it has this term that might seem scary, contested hearing, my understanding is, and we would certainly support a process that has is as informal as it can be. Obviously, if there are parties that show up, and we don't envision there ever would be, the HCA is not envisioning entering into this with any kind of activity that got party status. That might be a bit of a different world, but we don't envision that, and I think these can be handled, should be handled in a much more informal.
Yes, and I agree with Mike. I mean, we're gonna try to handle this as informally as possible, but there are certain requirements when you step into the contested hearing world, like having a hearing officer. We have to wall off the commissioner because the commissioner becomes essentially the adjudicator in these situations. So there's just a lot of process. We'll have to build a docket and so forth. We can certainly settle this up informally, if we all come to an agreement at the end, but we will have to go through the hearing process and let whoever wishes to speak. Normally, I think, I agree that normally people don't turn up for these meetings, but we'll have to make sure that we're prepared for that, because unfortunately, if you get into the process and haven't sort of followed the steps at the beginning, then you have a problem. So we'd have to assume that we're going to have some issues, follow whatever steps we absolutely have to under the law. And then, if we don't get the comments, don't get the interveners, then we can expedite the resolution of it and in a more informal way. But there's definitely steps we'll be stuck with.
I guess it's a question for both of you. When you talk about a hearing, you're talking about an APA hearing, notice, opportunity to be heard, evidentiary kind of hearing. Is that what we're talking about? Or is it some sort of less formal process?
If it's a contested hearing, we're talking about an APA hearing that's governed by the department's regulations and the regulations in state law. But there are ways to informally conclude that if all the parties are in agreement. So you can expedite the back end, but there's still a certain process you have to follow on the front end.
Yeah, just follow up on, and I appreciate that, and I suspect that many, if not most of these rate increases that are noticed will be resolved, before the formal hearing by agreement, I assume. I guess my question would be, Mike, is whether you could envision some process where you would file, some sort of notice or filing of some sort to indicate that you didn't see the need for a formal hearing, and thereby maybe get to that concluded informal resolution sooner rather than later, as opposed to setting off on the APA route from the beginning, Mike.
Yeah, I think given the timing, maybe the right thing for me to say is, I like the direction where what you just suggested. Maybe the right thing to do is to say that the HCA is certainly willing to engage with DFR and Blue Cross and anyone else as this bill moves along. I know the bill is going to have a stop upstairs, in-house healthcare. And so if there's ways of clarifying, we're not after a involved process that isn't worth it. And so we'll continue to work on finding the right language to land at the place that works best.
Thank you.
Yeah, I'm just wondering how long it would take to come up with another type of hearing or a less informal hearing than the one contemplated right now, a contested hearing. And I'm wondering, is that something that we could bring language to the Senate?
I think we have to stop upstairs so we could.
Yeah, but I don't think the bill, she's not going to take possession of the bill. I mean, can this be done like in a day or two? Or and I'd look to Jen maybe.
Certainly, I mean, as far as the drafting part is concerned, I don't think it will be difficult. It's just having the parties agree.
Maybe that's what we do, is ask Mary and Mike if you can work and with Sarah at Blue Cross to come up with a less informal hearing on that, so that we're not going into you know, a deep dive and then coming out of it in a shallow dive. Michael?
The concern is with the May is that it may not happen, correct? The hearings. Would it make a difference if it shall upon request?
So this is, I think, this is exactly where I was going and thinking that maybe there's an opportunity to work with the other parties to come up with language that sort of defines who can request a hearing.
But currently it's set up so that it shall, so it will happen. But if you say upon request, I mean, it opens it up to anybody, right? But currently it's shall. So it's always, but
You could say shall happen upon request of a few parties that you recognize or some percentage of the policy.
Right.
yeah, and that would kind of take care of some of that concern that you have, correct, Mary? But
I think, yes. The other thing that we had sort of been floating around is, and we don't have any case law, unfortunately, to sort of interpret whether we could do this or not, is to couch it as an informational hearing, to allow for the department to provide detail about the filing and receive public comment. There's no case law interpreting whether that would fly or whether it would still trigger the contested hearing statutes. So that was another approach, but we could, you're right, I think we could try to define, you know, shall occur. The one issue with that is particularly is in the beginning of the bill, we do identify whether a public hearing will have to happen or not. We'd have to take that out, obviously, because we wouldn't know if a public hearing was going to happen unless somebody asked for a public hearing, essentially. So we just have to take that language out of the first section.
Okay, I think we leave that up to the experts, and I think our healthcare committee, they're the experts on this. So we'll leave it up to them to draft an amendment to 137 on this piece. That work for everyone? Okay. Great.
Right.
Okay.
We'll get together with the Office of the Healthcare Advocate and try to come up with some language because we're all going to be in that healthcare meeting tomorrow morning. So
Okay, yeah, it'd be good, yeah, if you can touch base with Blue Cross too, and like
Yep.
everybody at the table, so everybody is understands and can give the thumbs up to something for the healthcare committee. Thank
Okay.
you.
we'll do that.
Jen, thank you. Michael, thank you as well. Mary, thank you. Maria, let's do the other new pieces that are within there.
Yes, good morning, Maria Royal with Legislative Council. So I'm going to share with you or share my screen. A document that has been posted on your webpage under my name. This is draft 1.3 of a Commerce Amendment to H 137. And I actually included in this draft the Medigap language that had been proposed last week. So we're just going to ignore that for now. Those are in sections, I think, 17 and 18. So, and I'll talk with Jen and we'll coordinate to make sure any new language gets in, or we just strike those sections and let healthcare propose an amendment. So that being said, the new sections for your consideration begin all the way on page, I think, 26, so all the way at the end. The highlighting that you saw in draft 1.2 has all been removed. So all of that language has been incorporated. Okay, so beginning with section 19. These are, the next three sections are all studies by DFR based on conversations I had with the chair, some of the issues that you've discussed, some of the topics that you've discussed as a committee. And the first one, section 19, you heard from Chris Delia last week about financial institutions and whether banks could impose a transaction hold in instances where there might be suspected fraudulent activity, and under what circumstances might that be appropriate. So Chris Delia did post some language about a model law that had been agreed on and all the different provisions. He went through that. There are other states that have enacted provisions. So what this study would do is basically ask the commissioner of financial regulation or designee to study regulatory models that would allow a financial institution to take measures to protect account holders from fraudulent transactions, and shall recommend a model appropriate for legislative consideration. And in doing that, the commissioner shall review regulatory models enacted or proposed in other jurisdictions. And then in terms of who the commissioner, there are different provisions here, but in terms of who the commissioner would consult with in conducting this study, it includes a representative from the Vermont Bankers Association, the Association of Vermont Credit Unions, AARP Vermont, the Office of the Attorney General, Vermont Legal Aid, and any other person deemed appropriate by the commissioner. And then in terms of specifically what's studied, among other things, the study shall include recommendations regarding the following: the financial institutions subject to the proposed model, so whether they're depository banks or credit unions, whether specific account holders such as seniors or vulnerable populations should receive heightened protection, notification and consultation requirements available to an account holder suspected to be the victim of fraudulent activity, a reasonable time period for imposing a transaction hold pending the outcome of an internal investigation, notification to the Department of Financial Regulation, and if appropriate, law enforcement or other third parties if fraudulent activity is suspected. 6, continued account holder access to funds for transactions not suspected of being associated with fraudulent activity. And then 7, immunity for any financial institution that acts in good faith to protect account holders and otherwise complies with any legal requirements. And then finally, a catch-all subdivision 8, any other provision deemed appropriate by the commissioner. So the commissioner then, on or before November 15th of this year, would report to this committee and Senate Finance with findings and recommendations in draft form, which you then could consider next session. So that's the first study, and maybe we'll just go through all 3 of them, and then you let me know what direction you'd like to take. So the second study is section 20, and this concerns protections for victims of coerced debt. So again, it's the commissioner or designee shall study regulatory models for providing protections and remedies for victims of coerced debt and shall recommend a model appropriate for Vermont. And in particular, the commissioner shall review the model state coerced debt law prepared by the National Consumer Law Center in May of 2024, as well as laws enacted or proposed in other jurisdictions. The commissioner shall consult with representatives from the Vermont Network, the Vermont Bankers Association, Association of Vermont Credit Unions, the Office of the Attorney General, Vermont Legal Aid, and any other person deemed appropriate by the commissioner. And then in terms of specific recommendations that you would be looking for, a definition of coerced debt, whether coerced debt should include both secured and unsecured debt, the requisite information a debtor must provide a creditor when alleging coerced debt, 4, procedures a creditor must follow regarding the investigation of an allegation of coerced debt, including ceasing collection efforts and notifying the Department of Financial Regulation, the Office of the Attorney General, and any other law enforcement personnel if appropriate. 5, whether a credit reporting agency should remove coerced debt from a credit report, and if so, the process for doing so. 6, whether Vermont's identity theft law should be expanded to more specifically reference instances of coerced debt, and what should be 7, any other provision deemed appropriate by the commissioner. And again, these findings and recommendations would be submitted to you in finance in draft form on or before November 15th of this year. And then finally, the final kind of study recommendation in section 21, this concerns insurance and access to genetic privacy or genetic information. So we'll just go through it. It's just this one paragraph. And so this would occur on or before November 15th. And for the purpose of preventing genetic discrimination and safeguarding an individual's genetic privacy, the commissioner shall provide a recommendation to this committee and Senate Finance on whether Vermont should enact a law prohibiting or limiting an insurance company's access to a consumer's personalized genetic report that is not part of the consumer's medical record. Among other things, the commissioner shall consider whether it is appropriate to allow a consumer to consent to the disclosure of genetic information obtained from a direct-to-consumer entity to an insurance company, including any company that offers health, long-term care, life, or disability insurance. So if you avail yourself of one of the services, I think 23andMe is one of the ones that does genetic DNA testing to let you know your lineage, et cetera. That information would not be disclosed to insurance companies. Or the proposal is, should it not be disclosed, and should the consumer have control over whether or not it is disclosed?
When we looked at this a few years ago, they aren't collecting enough information to determine health issues. But I don't know if that's changed since as well. I think it's probably a good idea to have this looked at and make sure that it stays the same way. You know, I think what we heard, there was a news article back last fall that talked about 23andMe, and they were having issues with their viability. And what happens if they go through bankruptcy, and what happens to all that information? Someone that might buy the company in bankruptcy or buy all their files and stuff. And so then what happens, and can insurance company get a hold of that information? Would there be any information relevant to genetics and show their predisposition for certain diseases and things like that? They could affect liability, affect their life insurance, things like that. So,
I don't think, and maybe I'm misunderstanding, but once the policy is enforced, it can't be changed. Then,
right, but if you're applying for a policy and if they're able to attain this information that might be out there without your consent, that's the issue of being able to obtain information without your consent.
okay.
Wasn't around for, the testimony I think you took. Certainly protecting privacy of genetic information is really, really, really important. I just don't have the background I think that you folks have had around what current law is now. I know there are some provisions around genetic information, but maybe they don't touch on the kinds of issues. So, yeah. If you folks say that, based on, what you've heard, there's some need to take another look at it. I assume the department thinks that that's not a bad idea too. So that's fine with me.
I'm wondering if we want the Attorney General to be part of this conversation or determination.
I don't think so. I think This is more on the insurance side.
It seemed to me that this is really an information gathering kind of thing.
Yeah.
If something comes of it, I could should, we could bring in other parties, but.
There's nothing that prohibits DFR from going to the Attorney General and see if they've seen anything.
I remember when this came, whatever it was, a few years back, and also part of the question was around, it was specifically around women who were having DNA testing for markers for possibility of cancer. And the concern was that if somehow insurance could get that access to that data somehow, but presumably that would fall under HIPAA, right? It wouldn't.
Well, that was a little different situation. The situation was that they wanted that information excluded from life insurance or health insurance, being able to access any of that data in order for someone that was applying for, say, life insurance. So if someone gets information that they have a marker that you could die within, the next 7 years or so. One thing you might do is go out and get yourself a life insurance policy. And if that data is excluded from being able to be sourced by the insurance company, you're not on a level playing field. So I think that was the issue back then. This is a little different. If the information is there, you want to make sure that people want that information to be accessed by any insurance company. They should give them, they should be able to formally say, yes, that's okay, you can access it, but they shouldn't be able to just go out and buy it from a data broker and then use that information to determine how someone's policy might be affected.
The different distinction is it's not part of the consumer's medical record. Right.
Yeah.
That's
Yeah.
that's important.
Yes.
Right, yeah, that's the issue, right? It used to be that you could only get this information in a hospital setting where you were part of a medical record, and today there are businesses that are not medical that can do genetic testing and do it and maintain the data and have access. And should that be able to be part of something else?
Mary, did you want to weigh in on the last three pieces?
So I unfortunately can't weigh in on the first two, since
Okay.
I was not involved, but with respect to the genetic privacy, we do have regulations and a statute on the books around the use of that information if it is not in a medical record. But that prohibition right now does not include a prohibition against getting the information. So that's some of the conversation that we've had about whether or not we should broaden that to say you cannot get that information regardless of how you use it, without consumer consent and it, being in the medical record and so forth. So that's the piece that I think we're looking at this point.
Okay.
It is part of our unfair trade practices right now to use it, unless it's part of a medical record.
Okay.
That's what I remember.
I think were we able to get in touch with Aaron? Deputy Commissioner for banking. Can we get in touch with him? So I'd like to come back to this afternoon after we hear from Vermont Arts Council, just to hear from DFR one more time from Aaron to make sure that the two studies that are in there, DFR, his office can handle that all right. Get the okay and then vote this out. Maria, your advice on the Medigap would be to just remove that section, reserve it, and then let healthcare put an amendment on it.
Well, that's entirely up to you. If you want to vote it now and there's no consensus on the language, then I can just delete the sections that are in here. And then there can be a floor amendment from the healthcare committees.
I think that would probably be the best route to go. Is everybody fine with that?
Have it in.
No, we'll,
Or take it out.
we'll take it out, we'll vote it out without it in there.
Okay.
And then let healthcare, finalize the language and I think that would be best on the floor as well. Because that's not really our purview, that's theirs. And then, everybody will know that we work together on this. Okay.
So I'll do a draft 1.4 when I get to my office that doesn't include the Medigap language so that you have
Okay.
and I'll also make sure it's edited. They're a little backed up there, so. You might vote pending edits, but I'll try to fix whatever I think.
Okay, great. Thanks, Maria.
Welcome.
Mary, thank you. We'll try to, is Aaron in the office today or is he on the road?
I don't know, but I have emailed him to let him know
Okay.
that you guys will be looking for him for some commentary later.
Okay, thank you very much.
Thank you.
So let's see if Doug is out on Zoom. Hey Doug, how are you?
I'm good, Mr. Chair.
So we're gonna switch gears now. We're gonna talk with Doug Farnham. We're gonna talk about the MCAT program. This is for budget. The governor's budget has $3 million, another $3 million for MTAT, which is a municipal technical assistance program. And I think Doug can give us an idea of how that program has worked this past year and the need for more money. So Doug, thanks for joining us.
Thank you for having me, Mr. Chair, and I apologize for not being in person. Just had a little bit of difficulty juggling where I needed to be physically today. So for the record, Doug Farnham, Chief Recovery Officer for the state. This $3 million is an additional tranche that matches the original appropriation of the Municipal Technical Assistance Program, and a bit of a recap on that program. It was established very quickly in collaboration with the legislature through the BAA, actually. And the purpose was to build and support as many projects as possible for communities with a lower amount of resources and capability to engage with state and federal programs. Because when we were monitoring, when we being the administration, were monitoring who was participating in our ARPA state fiscal recovery programs, we were seeing a definite trend towards communities with larger resources, communities with professional staff, being able to submit more projects, to submit more competitive grant applications. When we build programs at the state and federal level, we often build them with the best of intentions, but we build them with a lot of criteria and metrics, and it takes a lot of time to, there are good reasons, of course, when the legislature wants to know how money was spent, they want to know that it was well spent. And so for smaller communities, even answering all of those questions and laying out the business case and arguing that a project is meaningful to them and impactful, it's something they didn't necessarily have the resources in-house to do. And it also, if you look at a lot of communities, they're small enough that it wouldn't make sense for them to maintain the resources in-house to do those types of activities, because under normal circumstances, they just don't have the opportunities that they want to take advantage of. And so maintaining professional staff all the time would be a huge drain on their budget and wouldn't really pay off, because a lot of our rural communities are not looking for constant change. But they do want to take advantage of some federal opportunities that even with the uncertainty and anxiety created by the new administration, there are still a number of programs that are moving forward and opportunities that are still occurring at the federal level. And of course, we do still have our state fiscal recovery programs running. Now, most of those programs at this point have the state fiscal recovery programs have become fully subscribed at this point in time. because we had to have all of our projects obligated by December 31st of 2024. But there are still infrastructure programs in the Investment in Infrastructure and Jobs Act, or bipartisan infrastructure law, that are continuing to move forward. A number of the programs in the Inflation Reduction Act are facing a lot more uncertainty at the federal level, but there were so many programs created there that there are still some opportunities that would be great for our communities. The other overlay we have, and the Municipal Technical Assistance Program was created in the 2023 BAA before the July 2023 floods. And so it was originally focused just on the pandemic-related federal funding, federal programs and state programs. But one of the opportunities here that we've seen a lot of resiliency and hazard mitigation programs and early efforts for scoping out what a community might need to do to become more climate resilient, made it into a lot of the project requests because of the floods in 2023. 2024 certainly affected everyone's outlook, but at that point we had already fully locked in. We had already fully allocated the initial $3 million of spending. So at this point in time, Mr. Chair, we have a list of, and it is admittedly a bit stale at this point, but I'm confident that if we went out to reassess the list, it would only grow. We had, as of last spring, we had 1.4 million of unfunded projects through the regional planning commissions that they had worked with towns to identify. These are projects that would be in scope for MTAP support. They're eligible communities. And we just maxed out on the bandwidth for support. Because of the 2024 floods, we've seen a lot of communities much more interested in trying to manage their risks and adapting. So that's one reason we asked for 3 million. The other reason is when we approached the $3 million of MTAP, about 60% of it was allocated through the RPCs, and the other 40%, we entered into a contract with Stone Environmental. We worked with Vermont Housing Conservation Board's Rural Economic Development Initiative program. We worked with the Vermont Council on Rural Development. So a big chunk was RPCs, but then we bolstered a number of other tools available to smaller communities and trusted partners. I think the Council on Rural Development does a lot of requirements gathering, community needs assessments. They support that initial conversation phase of figuring out, okay, what does the community actually want to do? Because when we initially launched MTAP, we found that many communities, it's Vermont, so everyone had a slightly different vision for their communities, right? There wasn't one cookie cutter, hey, this is what everyone in Vermont wants to do. And they were all at different phases, but many of the smallest communities were still at the planning and conversation phase and still needed to work together to build buy-in on exactly what they should be doing. And because they didn't have professional and planning staff, et cetera, they didn't have the years of history of, you know, public meetings and scheduled meetings to figure out what the plan is and maintain a plan. And I know I'm jumping around a bit here. I hope it's still helpful. But one of the things I've been most excited about is the things that we've done with the 3 million so far is things like the town of Athens. We helped them get their first town plan ever, right? So that I think is a big step forward for a community to really pull that plan together and to agree on this is the path we want to maintain. It's a foundational document that without it, it's very challenging for them to compete for any grants because they automatically get dinged in most programs for not having that type of planning document that lays out their course. So whether it's good or ill, our current government structures really emphasize having a book of planning documents and work that most communities just don't have the materials to maintain. And MTAP has helped people help those communities catch up. And I do think that there are still significant opportunities for those communities over the next couple of years to merit additional funds to MTAP. We are still balancing out how we're going to spend our hazard mitigation funding We currently have, I think it's about 67 million awarded from FEMA, and then the state, being the we in this case, are putting in 25% match, so it's nearly $100 million worth of projects. That is always shifting around, and we do want to have as many options, as many viable projects on the table as possible, so that some of these communities that aren't normally able to take advantage of our programs have the full opportunity to engage. So, Mr. Chair, that's the main reason AOA asked for another $3 million to extend the program. I have limited service staff right now that are with the agency through most likely through June 30th of 2027 for the ARPA State Fiscal Recovery Program. And they kind of pull double duty and manage the state side of this program. At this point, all the connections are built, and the Vermont League of Cities and Towns is helping us with the coordination between our partners. And that would be a small part of what the 3 million would do, is help to support that ongoing coordination between the regional planning commissions, the Council on Rural Development, Stone Environmental, the League, and they would just be pulling that together and making sure that we're all talking, we're not wasting our time, we're putting the partner that has the most appropriate skill set towards the work. And I think the idea at the end of the day being, a lot of these communities, they just, again, it wouldn't make sense for them to maintain the capacity in-house to do this. And it is still a short-term opportunity that we're trying to take advantage of, or help them take advantage of. So that's my overview, Mr. Chair.
Thank you. Questions? Edie?
Hi, Doug. Can you remind me, and I don't want to confuse this with a different program, is this the program that a limited number of towns were eligible for? And if that's the case, how many of those towns actually responded and got help from the program? If I'm remembering correctly, it was a limited number of towns and it was a small percentage that even were able to get any support.
Yes, so we did actually, yes, let me walk through the history there. So we at AOA created the Vermont Community Index, and the MTAP program prioritizes towns that have a higher score on the Vermont Community Index. The way a town achieves a higher score there is all based on their demographics and their grand list capacity, their technical staff. It's a combination of the Rural Capacity Index, which is a national index, and the Social Vulnerability Index, which looks much more at human services side of the table. So it attempts to combine that human element with the pragmatic. Okay, what are your needs as a community, and what resources are you able to bring to bear to accomplish that? Because it's not just based on community size, because some small communities are rather affluent and are perfectly capable of meeting their needs and supporting staff. Others, even larger communities like Berry City, have some of the most distressing economic indicators when you pull everything together. Even though they're of a larger size, their population has significant needs due to economic conditions. So even though Berry is a much larger community, it actually is somewhere around 30% on the Vermont Community Index. So what we did was we first opened the program up to towns between 100 and 75% on the community index. So with 251 towns, that was quick math is my enemy in this case, but 63 towns or so, right? We opened it up to roughly a quarter of the towns in Vermont. And what we did see was when we first engaged with those towns, it was very challenging. We did not get as many bites. We did not get as much engagement from those communities as we thought as we were hoping to. So we did open the program up to towns down to 50% on the index. So half of the towns in Vermont, 125 towns, became eligible. So it was a prioritization method, but a large number of communities were eligible for the program. And when we did that, we also announced, a deadline of, hey, if you don't get your projects in by this day, and that was, I think, in December of 2023. If you don't get your projects in by December, we're not going to be able to consider them. And we did see engagement pick up significantly in the smaller communities when we put a deadline out there. And the RPCs worked with the communities because they had orders to prioritize helping those communities that had higher community index scores. So we did see a rebound and an uptick of towns with a score between 75 and 100 that got projects onto the list. But the largest concentration we have of projects is still between 50 and 75. So still towns that, if you look at their economic indicators and their capabilities, they still are actually a little bit below average in the score, which is good. They are a little bit more needy, but they're in that, a lot of them are in that sweet spot of between 1,000 and 2,000 residents, and they want to do things. They didn't have the means to figure things out, and they just needed a little bit of help to push them over the edge. What we still see with some small communities is they're so far from having the resources to do something. We're continuing to work with them, but they are still a bit underrepresented in the amount of projects, because it is just much harder and it takes a lot more work to kind of get those projects sourced and supported by the community. So the extra time and then the addition of the deadline did gain some ground back there. We did compile a report of in somewhere around July of 2024, we compiled a report of how those projects that were currently approved through the RPCs and other sources are, how they're distributed among the Vermont Community Index towns. And I can share that. It's a spreadsheet report. I can share that with the committee if it'd be helpful.
Thank you very much.
That'd be great. We have to get to the floor. John, a quick question.
Mr. Farnham, I was looking at the MTAP webpage and I find a 2-page report from July 1st or June 30th of 2023, but nothing from the 2024 sort of timeframe you mentioned. Is that something that maybe is elsewhere? Had you compiled that one from January 15th of 2024?
So we posted on the website, we posted the legislatively required reports. We haven't posted the Excel document because it's been more of an internal document. It's not a statutorily required report.
All right, the January 15th, 2024 one doesn't seem to be as easily accessed as the June 30th, 2023.
Okay.
Thank you.
I'll work on getting that corrected.
Okay, yeah, if you could send us those pieces, Doug, that'd be great. We have to get to the floor now, but thank you for joining us and giving us the report on where things stand and where we need to go forward.
Thank you, Mr. Chair.
Thank you. So committee, it's floor time, caucuses, lunch back here. No, we're in room 10 at 1:15. Okay, so be very prompt to be there at 1:15. It's a joint hearing with 2 education committees in the House and Senate. Hearing from Secretary Saunders and up in ATA.
You have the Stephen report. To read over last.
On the webpage, but I also have. Oh, it is posted. I didn't see it.
On education's webpage or our webpage?
This is posted on the webpage.
Okay, that's the one from,
That's the updated one? No,
that's the one, yeah, that,
This is the one from the joint assembly that we had
Oh,
in the.
yeah.
So there's not a new.
the updated APA report is.
take a look at,
We're getting that today. I'm still
Okay.
waiting to hear.
okay,
Gotcha, thank you. Thank you.
all right, so
Get a lot.